Okay, let me start over. Sorry, I had my mic muted again because I was out running around looking for my dog. So what I was just saying is sorry, I'm a little late getting started here and getting started with no mic. I had to get the dog in, and I had a phone call with a potential client that went right up until time here. So what I was saying is we'll be talking today about CPP disability. I'll talk about when it makes sense to hire a lawyer. Can you do it on your own? And I'll be looking forward to answering questions about any questions people have about CPP disability, long-term disability, or anything to do with employment, termination, and all that kind of stuff. Please just put your questions in the chat. I do appreciate Mary for telling me that you couldn't hear me. Okay, let's dive in. So, I need my notes. Let me get my notes ready here. Whew, it's been a busy start to the week. I hate to say it. Okay. Let me get you guys back up here. So why does this matter? Again, most people the majority of people do CPP applications on their own. Now it is high stakes, but it's not rocket science either. So in many cases, it makes sense for people to do their own CPP application. There are, however, times when mistakes can cause big problems, and there are times when each person should get help, whether it be from a lawyer, an advocate, or even a family member who might be able to handle it better. So while legal help from a lawyer isn't always needed, it's good to know the kind of situations where it makes the most sense. There are 3 stages of a CPP disability claim where you may want to involve a lawyer or have to make a decision whether you would. The first would be the initial application, reconsideration, and the tribunal appeals, because there's 2 levels of appeals there. Let's go over each stage in a little more detail. So applying on your own. So the first stage would be the application stage. There are some pros to applying on your own. Basically, you avoid legal fees. You can control the process. These would be reasons why you would want to do it on your own. And it can be a good option if your doctor is very supportive, your disability is clearly documented in the records, and your minimum qualifying period is current or recent. I won't go into huge detail about the minimum qualifying period is because that can be a whole session on its own, but This is a critical thing. If you are thinking about doing an application on your own, you really shouldn't do it unless you have a current minimum qualifying period or it is very recent, like within the past year. Like you're within the year of it type of thing, of it expiring. Now, the cons of doing your own application is it can be confusing, and there are just, if your disability is such that it may be just overwhelming for you, that could be a real problem. If it's overwhelming, you may not understand or can't focus enough on understanding the definition of what severe and prolonged means, and that can lead to like giving vague or kind of incomplete answers that can get kind of result in a denial. Okay, sorry, I was on the wrong. Now, I don't want to like overstate it, but some mistakes that you make can hurt you long term if you state certain facts or state things in a certain way. It can make it very difficult or impossible to fix the mistakes later. Now, most of these mistakes that are hard to fix come down around the minimum qualifying period. Again, this is the period of time you have to prove for CPP disability, you have to prove that your disability started when you still had a minimum qualifying period. Most people assume that you can just apply to CPP disability as long as you've paid into CPP. That's not correct. It's only available to people who became disabled from work recent to when they were making CPP contributions. And so you have to prove that your disability started while you were still in a minimum qualifying period. The minimum qualifying period is basically set out as 4 of the last 6 years. So you have to have paid in 4 of the last 6 years, and that 6-year period would be your minimum qualifying period. As long as you can show that in any 4 of the last 6 years that you paid in to CPP disability, the minimum payment requirements, then that is your minimum qualifying period. That is the period in which you have to show your disability started. If your disability starts outside of that period, then it doesn't matter. Like you can't qualify for CPP disability, even though you've paid into the plan, because your disability onset date was outside of your minimum qualifying period. This is a real trap for people who have been off work for a while and are trying to apply for CPP disability, or they've applied in the past and had a failed application and they're trying again. Anyone who's been into the workforce for more than 2 years because of disability and is trying to apply for CPP disability should not, in my opinion, be doing an application on their own, unless they really understand this concept of the minimum qualifying period. We see it come up quite a bit, and it can be devastating in some cases, because if a client has, let's say a client's applied on their own, they are not thinking of the minimum qualifying period. So they are focusing all their evidence and statements about when their disability started. And if they're focusing and saying the disability started on this date, which is after the minimum qualifying period, then you've got a huge problem. It's very hard for us to come in and then say, well, no, actually the disability started before then. It's not always clear when a disability starts. There is a period where it may seem like, especially if things worsen over time or if there's other events that happen, it can be very difficult to tell that story, to present that story, if someone has already said, nope, it got worse when it happened on this date. And it turns out that date is after the minimum qualifying period. Very hard to refocus this to be on a case that could prove going backwards in time that it was an earlier date. So just be very, very careful. If you hear of anyone who's trying to apply for CPP disability and they've been out of work for more than 2 years, just tell them to take extreme caution, because they are likely to have a lot of problems with that. Now, other cases that are hard to win would be ones with an invisible illness, like mental illness, fibromyalgia, chronic fatigue, post-COVID viral illness. Like there's all types of claims like that where you have an invisible injury or illness, that it's not something that can be picked up by x-rays or blood tests and these types of things. Those are going to be cases that are harder to win, and so more likely that you might need help. Now, if you've already been denied for other claims as well, that might be a sign that you probably need help on a CPP application. So if your LTD's been denied, your workers' comp's been denied, then that's a sign that you probably should get help. Okay. Now, second stage. So once you do your application, then you get into the reconsideration phase. Um, Again, you can put new information in at the reconsideration phase. It's not enough just to disagree with the decision. You will have to determine, like, why did they make the decision they did, and try to give new information to overcome where they're at. The reality is, at the reconsideration stage is difficult. Now, we have won cases at the reconsideration stage, but in most situations, many situations, it is just a formality. You just have to, like, get through the reconsideration stage and try to win your case at the next level. The reconsideration stage is tough because unless you get new information that really changes things, then they're just going to stick with what they've already decided. Where you can be successful here is if you did not give much information, that your doctor maybe was vague, and now you've got the doctor to clarify something, or you didn't provide all the medical records and now you've given them. There's things that you can clarify. So sometimes, like, the reason you were denied is just they didn't have enough information and they needed something clarified. And so those are the cases where you can win on a reconsideration. Knowing, like, part of the success is knowing what the thing needs to be clarified. They won't tell you. Often the letter you get, well, pretty much always the letter you get from CPP is not going to tell you the exact reason why. It'll just say the medical evidence does not disclose that you have a severe and prolonged disability, this type of thing. They really just send out a pro forma letter now. In the old days, they gave more information. They would cite records. They would say there's this, there's that. That does not seem to be the way anymore. Now they've moved towards just these letters that everybody gets the same letter. It's just a general statement. That leaves you in a spot where it's very hard for you to know, like, what is the real reason? What is the gap in information that I have to fill in order to try to win this case? Now, the way around that is to get a copy of your CPP disability file. Once you get that, you can see, like, more details. The problem is that you only have 90 days to do this appeal. It can take 60 days to get your CPP application sent to you. So more often than not, I am of the mind that I just try to get past this reconsideration appeal step with clients and try to win their case at the next step where we actually have a better shot. Unless it's clear when I look at the file and I can tell, okay, they're really missing this key information. Let's get it, send it in. Otherwise, you really can just waste time at this reconsideration step because you don't know exactly why it was denied. They're not going to tell you. And once you apply to the next step, so when you appeal past the reconsideration stage into the tribunal step, you will get a complete copy of the CPP disability file at that point. Get it pretty quickly. So that's the time when you can really take stock and assess this. What most people do at reconsideration is just have their doctor write another letter. That's usually not that helpful because the doctor's not saying anything any different. You don't really know if you don't know why the doctor maybe wasn't clear on the first time around, then you really don't know what they should need to clarify, and it can just be restating the same information. And if the doctor's kind of said something incorrect, or you're really in a problem with not having the disability starting during during the minimum qualifying period, then the doctor is just reinforcing this bad evidence that will kind of ruin your claim. So it's good to bring a lawyer in at the reconsideration stage. You've given it a chance trying to win this thing on your own. And if you haven't, like, a lot of cases do get approved at the application step. I don't want to pretend that they don't. The last time they measured it, it was like 40% of people get approved at the initial application. So a lot of those people are doing their own application. If you don't get approved, though, it is worth thinking of getting help with the next step. Unless that it's clear to you what could be missing or what the next, where you would go to try to get this approved. A lot of people will just sort of spin the wheels. And unfortunately, a lot of people will miss the deadlines on the reconsideration, then have to start all over. So don't let that happen to you. All right, now step 3. Sorry, I'm missing my So what's involved at the reconsideration? Sorry. You've got 90 days to appeal. You have to submit new or better information. And there are high denial rates at the reconsideration, 100%. If you don't have the strategy, what I kind of just discussed. So tribunal appeals. Tribunal appeals. There are two levels. There's the general division and the appeal division. You want to be, so just generally speaking, how it works is when you get to once you get past once you get a reconsideration decision, you have 90 days to appeal to the tribunal. You do that by filling out a form. It's not a complicated form. You just fill out a form and say that you want to appeal and send that form in. They will accept it and say, now your case is before the tribunal. You then have up to 2 years to get your case to the tribunal before a judge. Where you want to be, you really want to be cautious of doing your own tribunal appeal, especially if you've been representing yourself up to this point. Like, you've 2 chances to win and not 1, although granted, it's very difficult to win at the reconsideration. The tribunal stage is really, it's really it is your last chance. You do have 2 levels of appeal here, but the second appeal here is not guaranteed. So your best chance, where you have to put your best foot forward, is the general division appeal. You're not guaranteed. If you lose there, you're not guaranteed to have another appeal. It's not by right. This appeal is pretty much by right. Everybody gets one. The next appeal at the tribunal, you are not guaranteed to get one. Okay, so just keep that in mind. Where you can go wrong here is not understanding what it is about your case where's the problem. The best thing to do is once you file for this tribunal appeal and they accept your kind of appeal, they will send you a copy of Service Canada's files, and that is very important to go through and try to understand, okay, here's where their decision was, here's why they were deciding. It gives you hints at what information you need to get. But it's not going to be everything. You'll want to look for what are some red flags around my behavior or things in my medical file that I have to fix that are going to be of concern to a judge. I discuss all those types of things in my book, CPP, over here. So I do discuss it in my book on like things that are red flags that you have to be looking out for. Sometimes those are hard to spot if you're looking at it for yourself. A lot of people won't recognize or don't want to admit their own faults. It's easier for an outsider to look and be more objective about your situation. That's why a judge will often say a lawyer who represents himself has a fool for a client. It's the same kind of idea, that it is not smart to represent yourself because you can't be objective about your situation. And that can often lead to blind spots that will lead to denials in these cases. All right. Now, what does a disability lawyer actually do? The biggest thing is going to be determining the right strategy and getting the right evidence needed to win the case. These cases boil down to having the right story and having the right evidence to support the story. There are certain red flags that will really, if you don't fix them, will result in a 100% denial of your case. Things like the court not believing that you tried hard enough to stay in the workforce or go back to work. So you have to construct your case to show that that is not the situation for you. It's not enough for you to verbally say it. You need to be able to show it based on records and things like that. So that's number one. Another big red flag that I look for in these cases is any type of situation where other people are saying that you did not follow medical advice. Often you will feel like you did, but what I'm looking for is not what you feel like. What did other people say, and why are they saying that you did not follow medical advice? You have to fix all those things before you get to the tribunal, or it's going to be major problems and you will lose on a technicality. The court will not say that a disability is severe if a person has not followed all reasonable medical advice. Even if their disability otherwise would be severe, if they have not followed all reasonable medical advice, that is kind of an exception where they can find that the disability is not severe. Another thing that lawyers can do is they can help your doctor write more persuasive letters. Again, if you just write to a doctor and say, I need help, will you support me in this appeal? I need your help. They have no idea what to write. They're just completely coming out of left field. It's more effective if you write to the doctor and say, here are the key things here's the key information that the court needs to consider around this case. Like it might be your sitting capacity or how long you can stand or whether your symptoms are irregular. You have to figure out what it is for your case and have the doctors talk specifically about that. That can be very powerful because the doctor is talking about the specific things needed in order to win the case in your situation. What is not helpful is the doctors to make general statements overall, like don't think you can work, these types of things. If it's like another example would be if there were situations where you did not get a certain medical treatment and the government is arguing that you didn't follow all medical advice. Well, maybe you have your doctor talk about that and explain why it was reasonable that you didn't do it. And that even if you had done it, it wouldn't have changed anything. So those are the kind of things you would need specific evidence on that from your doctor. And that would be those types of things a lawyer would be able to pick out and write to the doctor to get them to fix it. Now, the traps a lawyer can help you. That's one of the other reasons to get a lawyer is to help avoid the traps. The biggest trap is the MQP, the minimum qualifying period trap. That is the biggest one that a lawyer will really help. That will just ruin the whole case. If you build a whole case around not understanding that you have to prove disability in the minimum qualifying period, you will lose, and you will be very frustrated because everyone agrees you're disabled, but the problem is you have not proven your disability started back in the minimum qualifying period because you didn't have medical evidence. Like to win a case like that, you actually have to get all the medical records going back however far. We've done cases like 10 and 15 years into the past. Like we won't even take on a case like that unless there's possibility of getting records 10 and 15 years in the past, because otherwise almost impossible to do. Unless you've had the exact same family doctor the whole time, then it might still be possible, but still very difficult. All right. So final thoughts are obviously not everyone needs a lawyer, but your chances of success go up dramatically if you're working with either a lawyer or someone who understands the process and system well. There's never been a study about this in Canada. I don't have it at the tip of my fingertips here, but within the United States has a similar program called Social Security Disability. They had a study where they looked at the percentage of successful cases in appeal for people who had representation and those who didn't, and it was quite a difference. Again, I don't have those numbers right in front of me, but that was a study published by, I think, the Social Security Administration themselves. I would also say, we are in the world of ChatGPT, and I'll be the first to admit that it is very helpful in working on legal cases and disability type claims and these types of things. So it is helpful, but you do have to be very cautious. It still can give very improper information, and it will create fake legal cases. It still does that. Although that does seem to be improving somewhat, you just cannot trust it to state the law correctly. It will be very convincing, but what it will do is create cases to stand for the propositions that it's saying. But other than that, it can be helpful to use something like ChatGPT, and that may allow people to do a better job representing themselves, but you still have to be very cautious about doing that. I would not want to rely on cases and case law and things cited by ChatGPT for the danger that a lot of lawyers have fallen into. It will do two things. It can make up cases that don't exist, or it will cite cases that are real but don't really stand for the proposition that you are citing the case for. So just be very careful with ChatGPT. If you need help, you can contact us for free consultations. We do represent a large number of people in CPP disability. I've done many, many, many cases myself in terms of hearings and that kind of thing. We are successful in getting people approved at different stages. Some people get approved right. We do some applications. I try to encourage people to do their own application unless it's complicated. We are successful at the application phase. We've been successful at reconsideration. But more and more I focus on, for difficult cases, I focus on trying to get them approved once we filed the notice of appeal to the Social Security Tribunal. Once that happens, we can still get the case approved by Service Canada before it actually gets to the hearing. That's usually the best time to try to get a difficult case approved. Some just have to go to the hearing. Like the case is so dependent on an assessment of your credibility and your own evidence to go with everything else that some cases will just have to go to a tribunal, unfortunately. All right. I'm going to leave it there on that. But if people have questions, I'm more than happy to answer them now. We've got, you can just put them in the chat here and I will answer them. I'm also going to check online for our disability claim forum to see if we've got any questions in there that I could answer. Oh, it looks like there's a few. So I'm going to share my screen, but if people have questions, I'll jump back into those. Let's go see what we got here. Here it is. So there we go. Let's see what we got. STD prior to EI maternity. Good thing STD can mean many things. In our world, it means short-term disability. Prior to EI maternity. Let's have a look at what this person's asking. I'm currently on paid short-term disability. My claim has been approved until the end of July, but I am due next week. Oh, due. Yeah. I know I have to apply for EI as of the day the baby is born, but I have two questions. Can I continue to get short-term disability instead of EI? It's higher money, and I know this will offset EI, but I'd rather get more money. Manulife is saying the claim will end if I apply for EI, but my case manager is never confident in her answers. When applying for EI for last day worked, would this become the day before the day of birth or when I go on STD leave? Yeah. These are difficult questions. So the problem here is unfortunately the answers to this will be in your group benefits booklet where it talks about most policies will say what to do in this situation. It's not always like the same thing. So unfortunately, you'd have to see what this person's group benefits say for short-term disability, or it could also be in the person's, it could be like in the employer's policies and things, procedures, because there's not really a one answer to fit all here. So for EI, and they're saying EI, but I assume they mean EI maternity, because this is also confusing because it's EI, but there's EI sickness and there's EI, parental leave, I guess is the right way to say it. So again, what date would you use? That I would have to look at that actually to figure out the right date. That's something I'd want to clarify with the EI people, but it probably would be your actual last day worked, like whenever the short-term disability, it would be the day. My gut feeling would be it would be the day when you went on STD leave. So unfortunately, it's going to be hard for people to answer this. Yeah. I would not weigh in and give opinions without seeing the benefits and things. But if you have the option, like this person may have the option to stay on the short-term disability, then it may be right to do that. I just would be cautious to give advice without seeing what's actually required in the policy. Some of the policies require you to go on EI maternity, that you can't stay on short-term disability if you are off on a maternity leave. I know it's different with long-term disability, so again, it would depend on how it's worded. All right, this is one I think right. This was an income splitting one where Again, I said it would depend on the wording. What was going to happen was there was going to be a splitting of income. So someone was off on LTD. Their accountants, for tax reasons, were going to start splitting the pension income between this person and their spouse. And they wondered if now getting this pension income would affect their LTD. And I said that they would have to tell the insurer and let them know and say what would happen. The problem is if you don't tell the insurer, and if the insurer viewed this as an offsettable payment, they could come back to you in 5 years saying, yeah, you owe us back. We just discovered this. You owe us back like $120,000 in past payments because we shouldn't have been paying you because you were getting these pension benefits. If you're reporting pension income as income, like you're getting into gray areas of like, yes, it's your spouse's pension, but if you're attributing it to you as income, you're now in a slippery slope of that. Could be the insurer might be able to offset that. Yeah, that's a toughy one. All right, let's see what else we got here. When does LTD end? I was born in April. 65 is a while, but I'm curious. This is the wording. Long-term disability coverage will end on the day you reach 65, less the elimination period. Yeah. I was born in April. No. No. It's going to end. So this wording is just here. This is just here in case you make a, like, if the only reason it's mentioning the elimination period is because if you just make a disability claim, like every time you start a disability claim, there's an elimination period, sometimes called a waiting period. So if you start a disability claim near your 65th birthday, there would be a waiting period. So if you were close enough to your 65th birthday, you would still be in the elimination period, wouldn't get it. So I think what I got to say is here let me just reply here. All right. So I'm just saying, what am I saying here? You would be paid until the day before your 65th birthday. The mention of the elimination period would not apply to you because you are already on an approved claim. That is there for someone who makes a new application close to their 65th birthday. Yeah, Caro is correct. Actually, I got to fix this. So the date of retirement, this is something you're going to watch for. So this person's policy says the day you retire. So I actually had I had two people within the span of a couple months contact me where both of them had retired while on long-term disability, and their benefits, their LTD was cut off. Retire is not just like a state of mind. Like there is, if you work for like government agencies, governments and things like that, you can do retirement is becomes like a legal status. You're retired. And that will, under some of these plans, that will trigger these, like retire means your employer putting you as retired status. If you put retired status, then it bumps you off the LTD altogether. Now, I had those two people contact me. One of them was just screwed. They did it, they couldn't undo it, and they lost out on hundreds and hundreds of thousands of dollars in future LTD benefits just from really making a bad decision and contacting a lawyer too late. The other person contacted me just as sort of an aside. They had already put the paperwork in, but I freaked out on the phone and told them to like hang up immediately and call the whoever and get them to just withdraw the paperwork, shred it, throw it in the garbage, like whatever, just stop the process. And they did it and they were able to stop the process. So their retirement did not go through for the second person. The first person it did, unfortunately, and they lost a ton of money. Very sad situation. There we go. Let me put my there we go. All right. What else we got here? Frequency of LTD checkups. So this one, have I already responded to this? Nope. Let's see what it says. I've been on LTD for approximately 3.5 years with Canada Life and CPP disability for a year and a half. Due to my medical condition, car accident, I doubt I'll ever be able to return to work. I've heard so many stories here where people have been left alone by LTD, and I'm wondering why that hasn't been my situation. I get a checkup every 3 months. I'm on my fifth caseworker. Oh yeah, they've all been the same. The phone calls are like interrogations. I stress about it in the weeks leading up to it. Yeah, that's bad. The one question in particular that always makes me feel like, regardless of what I've said something wrong. The question is, what do you do all day? Yeah. Yeah. Uh, I got to be careful how I write this. So for it, so insurance companies will eventually put all people on long-term claims. No, that's not right. How do I say this? The answer is that once the insurer believes that you have a permanent disability, they will move you to see, again, I don't like to say it this way because I don't want to comment on this person's exact situation because I don't know it. But what I'm trying to say is that if the insurer is still okay, the insurer only does frequent, most insurers. Now you see the problems of being a lawyer here. Most insurers this person's been on benefits See, I don't want to freak this person out because what I could say, like, they obviously, to me, obviously, this insurer has not decided that this person should be on long-term disability if they're following up every 3 months. So, but I don't want to freak them out and tell them that, right? So, because I don't know that for sure in their situation, it just doesn't make sense that the insurer is not going to devote all the energy to continue to follow every 3 months if they really believe that you are on a long-term disability. They would move you to their maintenance department where you get followed up once a year. So I'm going to say here, I'm just going to say most post COD LTD claims will go to annual there. We'll just say that. So Matthew's saying, if you are fired for frustration of contract in a unionized environment and the union does nothing, can you sue the company for pension benefits even if the insurance company's pays your wages? You can never sue an employer if there's a collective agreement. So no, the answer is no. Whenever there's a collective agreement, the whole purpose of it is that you do not have individual rights against the employer. So the answer to that is pretty much no. If you have disputes over pensions and benefits, those are all grievances that have to go through that grievance process. It wouldn't matter if the insurance company, I don't know what you mean by the insurance company pays the wages. You mean if the insurance company is paying LTD through the policy, like it still wouldn't matter. You would still, any actions you had against the employer would need to go through a collective agreement process. You don't have any rights to go directly against the employer. Now, you might have rights to go directly against the insurance company, and even if you're in a union, but not directly against the employer. I'm not sure if I answered that, Matthew, but you could let me know if that's what you're looking for. Okay, we got another one here. Let's go back and take a peek at this. So, cost of living increase. Okay, this is one of these old ones where people kind of chime in later. So this one came in 6 days ago. It says, hello, yes, my LTD claim had COLA, cost of living adjustment is what it stands for, in the agreement, and they haven't increased it 1 cent since I started 14 years ago. I looked over the contract that a fellow supervisor had got me, and it definitely has COLA. Okay, I think I talked about this last week, actually. Yeah. I guess I didn't reply to this person. So there's a bunch of problems here. Um, I remember talking about this last week because I was always cautioning people like this person's doing too much. They owe me just north of 200,000. My old lawyer screwed me. Oh yeah, okay. That's why I was saying not good to say my old lawyer screwed me if you're trying to get a new lawyer. If you really were screwed by a lawyer, that's fine. But I would more, rather than say that, I would say, like, I would talk to the new lawyer and say, here's what the other lawyer did, and let the new lawyer confirm that they screwed you, rather than kind of present it that way. You'll just present yourself as someone lawyers won't want to work with, because it's possible the old lawyer didn't do anything wrong. It's possible you got screwed too. So I guess the problem in these kind of there's lots of problems with this type of situation. So one, it's 14 years ago. So there's limitation periods where you can do things. So just depending on when you discovered this problem, especially if you're saying that it was in there, if you're saying that your policy had a COLA and they haven't paid it for 14 years, well, you should have sued them within 2 years, right? Even if you didn't have access to the policy, then you still are deemed to, like, know what the policy details are. So this would be a very problematic case to do. The second thing is that this person's relying on we don't even know if they're looking at the right policy. If your workplace, like, workplaces will replace policies over time, and the policy that will apply to you is the one that was in effect when your disability started. So it's very common that, like, 14 years ago there was a policy, and all the people that went off on disability while that policy was in effect, that policy follows them forward for the rest of their days, right? But, like, a few months after this guy, they could have got a new policy, a new version from the same insurer or from a completely different insurer. And so the new version that could have come out a few months later, even you would still be on the old one, and all the new people who got disabled would be on this new one until it expired. So there can be different versions of policy. So this would be hard to untangle. You'd first have to figure out, like, what policy was in place. That would be the first thing I'd want to see. How do you know you have the right policy? When did you first know about this? And if you're saying it was in the policy, then you should have known about it 14 years ago and should have brought the claim then. Unfortunately, like, legally, even though you might not have the policy, legally you are deemed to know what's in it. Otherwise, people they cannot do anything and say, oh, well, I didn't know anything. Like, the law wants to encourage people to act on their rights and to understand what's in the policy. So unfortunately, I do think this is kind of a situation where this could be not as easy as this guy thinks to go after this $200,000 and what they might owe him, because of there's a limitation problem here, most likely. I'd have to see everything, but and it's not always 3%. Like Jammer's pointing out, the maximum is 3%, but it could be lower. So if the inflation was lower than 3%, then it would be lower. And up until, like, 2020, there were a lot of years where inflation was low. So the cost of living would be under 3%. But there's also years where it went over 3%, but you'd only get the 3% because that's what it's capped at. All right. All right. I think that's it. All right, folks. Looks like we got a good group here today. Any other questions? Okay, here's one. Let me get rid of this. How would you get a hold of a very old policy? Yeah, it's tough. It may be almost impossible to get hold of it without a lawsuit. You would go through the employer, would be how you would have to start. You'd go through the employer and try to get you'd have to exhaust all efforts to get the employer to give it to you. If that all failed, then you could get the insurance company to try to get you a copy. In some provinces, I don't have it on the tip of my right in front of me. There are some provinces where it's legally required for the insurer to give a policy if requested by the insured person. Now, the problem is with some of the group policies. Again, I think the rules are written. If you're a group member, if you're a part of a group policy, the insurer has to give you a copy of it. If that's not in the legislation, then the way the insurer interprets it is that you have to get it from your employer because the policy is between the employer and the insurer. And you are a beneficiary of the policy, but you're not part of the relationship directly. So if you're going to get it, you have to get it from one of the parties directly, and they say get it from the employer. So you'd have to go through your employer, and then if that doesn't work, you could go through the insurer to get it. It's often a problem. Again, in litigation, I had a litigation recently where the other side originally produced the wrong policy, and it made a big difference. It was noticed, and then we went back. They then produced the correct one. I know for a fact it wasn't done intentionally. It just can get confusing. But the insurer would definitely have it. All right, folks, I'm going to take off now. It was great. Sorry I started out with a mute again. I'm glad Mary let me know immediately that I was doing that, because that's a big mistake. I don't have any other way of really noticing it. That's all. So I'll see you back here tomorrow, and wish you guys all a good evening. Take care.